My lord, can I just mention for a second?
Huh?
Item 23, I was not there, but I bow to what my lords have passed that order. Just give me one line with liberty to approach the court for a hearing because the rights have been closed. The state is going to be heard on 8th.
I'll correct it.
Just one line, sir. Grateful, sir.
24. अब कौन सा आएगा?
30, item 30.
Your Lordships, I appear for the Group D employees. There are 3 petitions, Your Lordships. This is SLP numbered also. And they are not in the list, but Your Lordships may also take into account. This is SLP 10617. I'll give the details, Your Lordships. They are there. And Your Lordships, some of them are cancer patients. They are Group D. I represent only the 48 people of Group D, Your Lordships. And Your Lordships will keep that in mind while deciding this.
All right. Can you, all of you, just wait for a minute? If there are some 1 or 2 small matters where we finish in a minute, we can just call out so that those lawyers can go some appointment of a substitute arbitrator or something like that. We just wait. We are not passing it over, but we'll just call out the other matters.
Wait.
This is 32. West Bengal is 30.
30, item 30.
All right. We'll just call out 31. Just don't, just call out. Let's see what's happening. We'll take it up after the West Bengal matter. It'll take just 5 minutes. It'll take. 32, Sarvesh Mathur. Parmeshwar, you're there? Parmeshwar, if it doesn't reach today, for some reason, we'll take it up tomorrow. Tomorrow, or do you want it day after? We'll keep it tomorrow. Sorry. Friday will not be possible. Then we'll keep it day after tomorrow. We'll take this. Oh, yes.
33, my lord, is that matter which we had last Monday.
Justice Shri Krishna's report.
Yes, my lord.
What is the order you are appearing for?
I am appearing for the state of Karnataka.
All right. Today, what is to be? Anybody else?
Yes, Minister. I'm for the petition number 1 minutes for the mic.
Mr. Naganand is there for the private party on the one side, and I think Mr. Abhimanyu Bhandari
Yes.
was there on the other side.
I am for one of the parties. Your Lordship, take it up after some time.
We'll take it after West Bengal.
Please, Miller.
Please.
After West Bengal, we take.
Please.
Because there's a report by Justice Shri Krishna which we have to pass some order on it.
Pending since August 23.
I know, because then they said it. Justice Bopanna's bench said before the regular bench.
16th October, that was
I gave my lord the option of hearing it in a combination of 3. I said you can, but my lord is retiring, so he said let it go before some other.
because of the audit.
Right. If not today, we'll take it up tomorrow. No difficulty. We are holding the matter back.
Please.
So right after West Bengal.
Great.
Great.
34.
Lordship, on behalf
Appointment of arbitrator, item 34.
It's
And the
an-
petitioner.
It's an appointment of an arbitrator, right?
Please, my lords.
Lordship, the respondent opposes this petition because there's no existing arbitration agreement between the parties.
Why?
Listen,
Your Lordship, if you may turn to page 56 of the petition, you'd notice that the agreement is not signed by both parties. It's only signed by the respondent number 1, but it hasn't been signed.
my lord, they have accepted money on that basis of that agreement, my lords. That's the admitted position, my lords.
Lordship, the term,
They are
of the
replied-
agreement- the term of the
All
agreement.
right,
never
let's
came.
see. Let's go to item 34. It'll take us 2 minutes. Just 1 second.
Petition is clause at.
Just 1 second. You're for the respondent, right?
Your Lordship.
Where is the arbitration agreement shows that?
It's page number 56 of the arbitration petition. Your Lordship.
Annexure P2.
P2. Yes, indeed.
My lord, P3,
P2 is just a letter.
please, my lords.
Your-
P3 is that arbitration, like, my lords. At page 53, my lords, if you see. It's arbitration clause. Article 12. Dispute resolution, my lords.
Was the contract signed by them or not?
No, Your Lordship.
My lords, it was signed by them and I have accepted also, and I have
Sorry?
I have accepted that and I have paid the amount also that they have stated on the basis of this agreement, the amount,
How much do you pay them?
please, my lords, 5,000 euro, my lords.
It is
My lords,
further.
page 50, my lords, missing.
But the assignor is only the assignor has signed the arbitration. The whole contract is signed only by the assignor.
Exactly.
My lords, and they have accepted the money on the basis of this agreement.
Is it correct that you accepted the money on
Money
this?
has been accepted further to a previous agreement, which is from 2012.
No,
And
This is not a correct position, my lords. My lords, may I see page number?
When they paid you that money,
Mhm.
what was the receipt which you issued them?
Your Lordship, we haven't received an issue. We haven't issued a receipt. There's a letter that was issued, which is also part of this petition.
Now, when you gave them the 5,000 euros, did you pay it under a particular letter? Did you communicate?
My
with
lords,
them?
it was transferred, my lords, electronic transfer
This is-
by Swift, my lord. That's
What
why
is the
that's
date of the agreement? 18 March 2016.
16, my lords. And my
And
lords,
when was the money transferred?
my lords, may kindly see, my lord. My lords, in the agreement, in the reply to my legal notice, my lords,
Yes.
reply to my legal notice, they have accepted that they have received the amount of 10,000 euros, my lords, on the basis of this agreement.
Your Lordship, the money wasn't accepted.
Just one second. Where is the letter exhibit annexure P5?
P5, yes, a reply of respondent, page 64 to 69. And my lords, my page. And at page 67, my lords, may kindly see. Page 67. In summary, the clause 3, we recognize that your client has paid euro 10,000 as part payment towards the second agreement. This is their letter, my lords, which they are saying.
And second agreement is this agreement in respect
Please,
of.
and in which the arbitration clause is there. They have accepted that, my lords.
That they didn't sign the agreement.
My lords, they have signed, my lords, and as per that,
You say in your letter,
yeah,
this letter at annexure P5, P5 is their letter.
their letter, my lords, this is not mine. This is reply to my legal notice, my lords, in which they have admitted that they have deleted the content from the Dropbox. At the same time, they have admitted that on the basis of that second agreement.
And they say we are willing. They say we are willing to adjust these dues against the dues of the first agreement.
But my lord, that can't be done because they had a termination letter which they have sent to us that they are willing to terminate the letter because earlier the first contract was with the the future in wild with Germany, and that was taken over by this the respondent number 1. And then they made us to sign a second agreement, my lord.
Your Lordship, if I may draw your attention to annexure P2, the letter that he's referring to, that is also a letter that hasn't been signed by either of the parties. So there's no agreement on termination of the previous agreement.
But you're signing that.
Earlier termination was not signed by either of the
It
parties.
hasn't been signed by either party either.
But my lords,
The only thing is, why did you then accept the 10,000 euros?
yes.
Your Lordship, the money was accepted. I mean, the
Then-
position's been made clear.
And what you say is now we are willing to adjust this against the first agreement. So you really accepted it under the second agreement. Otherwise, why would you accept the money? So what we'll do is we'll appoint an arbitrator, keep this point open.
Your Lordship, if at all there's no arbitration agreement between the parties, and a civil suit for recovery is the more appropriate remedy if it has to exist.
Payment towards.
Please, my
Your
lord.
Lordship, we continue to oppose it because there is no arbitration agreement between the parties.
How much is it?
My lords, it's around 23 lakhs, my lords.
22 lakhs.
Please, my
Your
lord.
Lordship, we
Because-
even tried to settle it with
22
them.
lakhs of rupees.
Please, my lords.
Oh, the arbitrator will eat up all your claim.
My lords. Then, my lords.
Give it up. 22 lakhs is not worth it. Lawyers' fees and arbitrators' fees will exceed 22 lakhs.
But my lords, the point
Lord-
remains that this
Lordship,
agreement was there, my lord.
On a previous occasion, we've tried to set.
Then, my lords,
Your Lordship, if Your Lordship, if we may be referred for mediation, that would still be an avenue of resolving the dispute between the parties.
It's 22 lakhs of rupees, not 22 lakh dollars.
No, my lord. No, my lord. It's only 24,000 euros, my lord.
24,000 euros.
Yes, my lord.
That's what it comes to approximately.
That's right, sir.
24,000.
The application seeks the appointment of an arbitrator in an international commercial arbitration. Full stop. The petitioner relies on the claim in arbitration is based on an alleged agreement. It's called license agreement, right?
Alleged, my lord, IP license agreement.
Where's
Intellectual
the
property.
agreement? Right. And in an agreement, comma, styled as an intellectual property
Property license
license,
agreement.
a copy of which is annexed at Annexure P3 to the application of the petition. Full stop. In response to a legal notice dated 9 May 2000, and in response to a legal notice to an arbitration, to a notice dated
Notice dated, my lords. Reply to the notice dated, legal notice, my lords.
the notice was dated 5th June 2018.
That's 5th June 2018, my lords.
September 2018.
Notice.
That's correct, Your Lordship.
5 September 2018, into brackets. Annexure P7, comma.
Yes, 5th September 18.
P7 is 5th of September, my lords. No, my lords.
Come on, tell us the dates.
Please, my lords,
Get a short order.
legal notice was issued on, my lords, at 9th of May 2018, and the reply of respondent came
9
on,
May 2018.
and reply of respondent
The
is dated
respondent.
25th of May
This
2018.
response dated 25 May 2018. Next.
Please, my lords.
According to the respondent, comma, there is the intellectual property license agreement, into brackets Annexure P3, has not been signed by it. Full stop. However, the letter of the respondent dated 25 May 2018, into brackets Annexure P5, contains a specific admission that an amount of euro 10,000 was received in part payment. Full stop. However, the respondent indicated that it was prepared to offset the sum of euro 10,000 against certain dues in respect of an earlier agreement. Next. In this backdrop, comma,
There's
we are
a
of the view that
confusion,
in this backdrop, comma, we are of the view that it would be appropriate and proper to direct to appoint an arbitrator, subject to the stipulation that all questions, including that all questions and in all defenses would be kept open to be heard before and decided by the arbitrator. Let's stop. Allow the petition by point Ms. Pritika Divedi, Learned Counsel, as sole arbitrator under the Arbitration and Conciliation Act 1996.
Much obliged, my lords.
All those.
Item 35.
Much obliged, my lord.
Before arbitration simultaneously on virtual basis. Like senior counsels.
Like senior counsels.
It's really something. It's also for arbitration.
You know what he was saying? I heard.
That's on the other part.
Much obliged, my lords.
35. Mr. Shankaran, you appearing? Sorry. Are you in 35 or no? 35, what is to be done now? Justice Ahmadi has.
But I appear for the respondents. in this.
Mr. Mehta, do we appoint some substitute in place of Justice Ahmadi now?
Lord, we have raised two objections to this, my Lord. According to us, this is a post award application. The award has already been
Section 33(4), right?
33(4), and they've taken out an application under 13 for removal of the arbitrator appointed by us on the ground of bias. So, my Lord, that application has been made by them. The two arbitrators appointed by the parties have made allegations of bias against each other in their respective awards. Lord, it's a bit of a tricky situation, and according to us, Lord, the applications have stood disposed of by orders passed by the tribunal before His Lordship Justice Ahmadi passed away. So these are our contentions.
Applications were disposed of by the tribunal.
According to
No,
us,
it's not been disposed of.
according to us, they are. My learned friend will of course say to the contrary.
So where is the order disposing of the application?
My Lord, there are three orders. If I can,
That was a letter that he had written only to that party, saying that, look, I'm finding it difficult to proceed. And that's something subsequently
Justice Ahmadi
withdrawn.
wrote a letter.
Yes, only not to us, only to that party with reference to the application. But subsequently, the tribunal has taken a call on that, asked for replies to be filed, etc. And then unfortunately he passed away. So now those applications, both the 33 and the 40, it has to be considered by the tribunal.
So there's one application under section 33(4) and 33(1)(a),
Yes,
and then followed by applications under 13(2) and 12(3).
yes. Yes.
Whatever, they let them take a call.
Absolutely. So let somebody be appointed, whoever it is.
We might as well appoint somebody there. Two arbitrators, Justice Patnaik and Justice R.J. Kochar.
Yes.
Able to appointing anybody there.
They're not able to find a common point.
Yes. Following an arbitral award dated 15 January 2020, the arbitral tribunal consists of Mr. Justice A.M. Ahmadi, Mr. Justice R.J. Kochar, uske pehle, Mr. Justice G.B. Patnaik and Mr. Justice R.J. Kochar. Following an arbitral award dated 15 January 2020, correct? The date is correct. The petitioner filed an application under section 33(4) and section 33(1)(a) of the Arbitration and Conciliation Act 1996 on 14 February 2020. Followed by an application under section 13(2) and section 12(3) on 28 February 2020. It appears that the arbitral tribunal issued
Well, that's 27th.
27th February. It appears that before the arbitral tribunal could take a final view, one of the arbitrators, Mr. Justice A. Mehmadi, passed away on 2 March 2023. But stop. An application for the appointment of a substitute arbitrator has been moved. Stop. In this backdrop, we direct that Mr. Justice Vipin Sanghi, former Chief Justice of the High Court of Uttarakhand, shall stand appointed as an arbitrator so as to complete the composition of the arbitral tribunal together with the other two arbitrators who have already been appointed. Stop. The application is accordingly, the petition is accordingly disposed of.
Wait.
37. 36.
37, I beg to put the petitioner, Your Lordship.
36, who's appearing for the other side? Who's appearing, Mr. Ahmadi?
Your Lordship, Colonel Balasubramanian sir is in court, held up in court before him.
Let him come. We'll just roll it over. Maybe after the West Bengal matter. We'll see if it doesn't reach by the end of the day. If this matter takes time, then we'll see where we can
Your
take it.
Lordship, then just stand it over to next day. This is one of those matters relating to the Air Force.
All right, take it up next week. We'll take it up. Update some carriers.
And would Your Lordship give me liberty to file on them?
Yes, you can file it.
I'm ready.
37, I appear for the respondent. We've moved two applications because according to us, another company, CEFAM, has to be made a party. So if they have no objections, these applications can be allowed.
We have objections because this is a bipartite agreement. CEFAM is one of my.
But they're relying on Cox and Kings. This is a classic textbook example of legal relations with that company because there are common.
You're for the respondent.
Yes, yes. So
But the arbitration agreement is between whom?
Between the two entities.
Petitioner, the respondent,
and Amos.
we don't just clarify there is no arbitration agreement with CEFAM, but we rely on Cox and Kings to say we have legal relations with CEFAM.
Who you are the respondent?
Yes, yes.
That you have legal relations?
Yes, because we have common promoters.
Compel him to impeach CEFAM?
No, not compelling him. On Cox and Kings because the supply of machinery was made by CEFAM. This whole transaction of payment of the machinery was supplied by CEFAM.
To you?
Yes, yes. No. Well,
You're for CEFAM?
Yes, yes.
Can I just say one thing, Your Lordship?
Who supplied the machinery?
CEFAM supplied the machinery.
To Mr.
No, to the petitioner who then, I was shown as the consignee.
Right.
So we have the invoice itself as an annexure to the counter affidavit.
Can I just get the numbers, Your Lordship?
Assuming CEFAM supplied the machinery to the petitioner.
No, Malaks. What happened is CEFAM supplied it to me through them.
Right. Fair enough.
Very well.
But that was his contract with CEFAM.
No. His contract is with me.
Right. But his contract with you, does it say that CEFAM will supply the machinery?
No. The invoice that was raised, that's what I'm trying to say, Malaks.
And
invoice
just
that was
clarify
raised.
one thing.
Yes.
Out of machinery worth $8 million, only $3 million is picked up from CEFAM. So for $5 million, I have other contractors.
That's not quite true.
That's the figures I've got from the client. That
I have the invoice.
But in any case,
yes,
his contract is with you.
Please, Malaks.
Now, you were shown as a consignee. He purchased the machinery from CEFAM.
Correct.
Showing you as a consignee.
Correct.
But surely, in your contract with him,
We
you are
have
the two
common
contracting
promoters.
parties.
This was only a convenient arrangement. The payment has to go to CEFAM.
And CEFAM is not even
This is a
mentioned.
convenient arrangement.
Who are you to say whom the payment should go to?
They're common promoters, Malaks.
He is obliged to pay CEFAM?
No, he doesn't.
Yes.
He disputes that.
But
He says he has to get payment.
Has CEFAM filed any claim against you?
No. Malaks, we have common promoters. May I just submit?
Who has common promoters?
The respondent and CEFAM have common promoters. The arrangement was that CEFAM will supply the machinery. It will be supplied through him to me. That was the arrangement. I'm in Uganda. CEFAM is in Chandigarh.
CEFAM is in?
Chandigarh. So this was a known arrangement. In fact, when they went for mediation, they did not object to CEFAM coming into the mediation.
We did object. In fact, that's
the
a letter.
mediation became a non-starter. So I have two proposals, Malaks. Either we can again go back to mediation, failing which we are not objecting to the appointment of an arbitrator at all. but we are keen that
How
SEFAM be
much is
part
the
of the
claim?
arbitration.
How much is the
The
claim?
claim is around
Unless
$8
he's
million.
claiming 7.7 million, but much of it is on interest. The actual
How much is your
disputed,
claim?
So $8 million, which will be around 70 crore rupees.
well,
They
most
have
of it is
admitted the
interest. The
principal
real
amount.
disputed amount is 2.6 million.
That's the principal amount. They're saying we won't
Whereas
pay you
much
interest,
of it
we'll pay
is
you
inflated
principal.
because of the
This is for
interest.
goods, the machinery which was delivered to them.
So
and
I'm a contractor in India. I take machines from various people. CEFAM gives me 3 million worth
Well,
of
that
machinery.
is disputed.
5 million worth of machinery I get from other people. In fact, in the counter affidavit, they say even Quad Life Sciences, another company you picked up machinery from. I picked up machinery from Europe as well. Where
Would
out
your
of
lordships-
8 million worth of machinery, only 3 million supplied to CEFAM. It's
Would
one of
your-
my subcontractors.
Would your lordships just,
One
You
second.
can claim its particular monies from me under a contract with me. In the contract between me and the respondent, that's the Ugandan
well,
company.
would your
CEFAM
lordships,
is not even mentioned. From me to them, with CEFAM having no mention.
well, it's,
So I am a contract supplier of machine to the company that is represented by Dr. Mulidhar. And under that agreement, CEFAM is not mentioned. I am the supplier. I am supposed to be paid for those goods. If CEFAM raises a claim on me for that around 40% of the machinery that was supplied to Uganda, I'll deal with them separately. In fact, I have other subcontractors also
no.
who might raise claims on me. In this agreement,
Well, it's, can I just show one document? 1 minute, please. 1 minute. Can I just show one document?
so there's a small dispute there. We are saying it should be Chandigarh because it has no connection with Delhi. They are saying it should be Delhi. There are some indications in the agreement itself which says it should be Chandigarh because the agreement was signed in Chandigarh and it defines business day as having a business day in Chandigarh.
May I just show one document if your lordships will see? Just one document.
Pipeline. Look, he has a contract with you.
No, can just show one document.
Yes.
Just one document, page 54 of my counter affidavit,
What does it say?
annexure R5. You should just see the invoice. That will make it very clear why we are saying what we are saying.
Yes.
Annexure R5, page 54
Yes.
to the counter.
PDF 82.
This, your lordships will find, indicates me as the consignee. This is an invoice raised by CEFAM. Me as the consignee and they as the buyer.
Was it a genuine transaction or some round tripping was going on?
No, there's no round tripping. Malas, there's actual machinery supplied. There's no question of round tripping.
Yes. Where does it say that you are the consignee?
Malas, CEFAM is the invoice raiser. At the, your lordships will see consignee, Amos Diaries Limited on the left side. Consignee is Amos Diaries.
And just below
And
that,
below
you see the
that
buyer.
is the buyer.
It's the petitioner.
Yes.
That's a sell. Yes.
So this is the
But
tripartite arrangement.
simple thing. If CEFAM lays a claim against you,
Yes.
your simple answer would be that, hey, I never had a contract with
No,
you.
which is why Malas, this is
I'm obliged to pay.
this is the classic Cox and Kings, because for Cox and Kings, your lordship says no need to lift the corporate veil as long as you establish legal relations.
You can move the arbitrator.
We'll do
They've
that.
Also say,
We'll do that. We'll do that. We'll move the arbitrator to implement CEFAM.
On the venue, may I just say two things, your lordships? On the venue, your lordships are deciding Delhi or Chandigarh. In the agreement itself, there's a definition of business
We
day.
have heard same for the petitioner and Dr. S. Mulidhar, Learned Senior Counsel for the respondent. Full stop. There is an arbitration agreement contained in the contract dated 21 August 2012 for the export of milk-related machinery. Full stop. Bearing in mind the arbitration agreement, we appoint Justice Sanjay Kishan Paul, former judge of the Supreme Court, as sole arbitrator under the Arbitration and Conciliation Act 1996. Stop bearing in mind that the arbitration is an international commercial arbitration, we request the learned arbitrator to fix the schedule of fees in consultation with the parties.
May I just
Well,
say
look,
one
on CEFAM, your lordship, they asked for CEFAM to be impleted, and we'll move the arbitrator for that.
You can always, this order.
Well, but we have raised
May I
the
say one
plea,
thing?
specifically we raised the plea.
Clause says under an International Arbitration
In
Association.
fact, we
that's
filed
the
two
clause.
applications.
So your lordship may associate some association also because the clause at page 40 of the PDF says it must be under an arbitration association of the country. Can I just show you
Oh,
something?
that's all right. We have
Yes,
exercising.
I mean, I have no objection,
The
but
menu of the arbitration.
On the two applications, your lordships can say we can move this.
The arbitration shall be Delhi. In view of the above order, the applications, there's a separate application by you.
Yes, yes.
The applications which have been moved in these proceedings on behalf of the respondent and the intervener
Yes.
shall stand disposed of with liberty to adopt appropriate proceedings before the arbitrator.
Very
obliged, obliged.
Very.
Please now, we have heard enough about this matter. Yes.
Obliged.
The report has come.
Yes.
Lord, I have filed an affidavit based upon the report. My lord, there were 2 points which persuaded your lordships. My learned friend's written assertion as well as oral which is recorded that 10,000 trees are uprooted and there is an eviction of people who were, of the workers who are staying there. Now, my lord, I have filed an affidavit and the report also shows that there are 89 trees which are cut. One of the statements recorded by the secretary of the...
But these statements which have been recorded seem to suggest that about 200 to 250 bulldozers were there at the site and the entire site was being cleared. That's the statement which the DLSA secretary has recorded.
Correct. That is for the purpose of bushes. There are 2 to 3 feet bushes. I have shown the photograph.
Right.
There are tea bushes. They are regularly cut every year.
But you're not running a tea estate.
No, I am not running a tea estate.
So when you were clearing the ground for the
Therefore,
airport,
Lord, I made a statement.
you had to get an EC.
And 42 lakh bushes were also.
You are appearing for whom, Mr.
I filed an intervention application on behalf of the workers there, only on the environmental issue that I'm assisting your lordship.
Lord, therefore, my lord, I made a statement on affidavit that nothing will be done, even preparing the land will not be done till we get the permission. But, Lord, just Lord, to point out, Lord, on 22nd, when the matter was heard, I raised the objection against Mr. Bhushan's client that he is staying at 300 kilometers in somewhere in Calcutta and prepares a self-serving report. Immediately thereafter, 7 of the people, Lord, files intervention. Well, that's coincidence, and I take it as a coincidence.
Not a coincidence. I was examined and I have filed an intervention.
Yes, that's okay.
I'm one of the people who gave the statement.
That's okay.
Will say that until the environmental clearance is granted, the status quo will be maintained.
Yes.
Thereafter, parties will abide by the environmental
your
law,
lordship
subject to their rights and
Environmental clearance. Just one minute.
I am a respondent, my lord, if I can be
Yes.
permitted
Yes.
by the intervener. Lord, page 3 of the affidavit which I filed. Well, did your lordship get the chance to go through this?
Let's see the app.
Well, it's an application, IEA, my lord. Lord, I would request your lordships to have it on Monday and go through this application.
That's an application that they have filed.
He's laughing at himself.
Asking for contempt proceedings
Yes,
to be
yes, my lord,
drawn
he's
up
laughing at
against
himself.
us. Because, my lord, we had stated that about 10,000 trees have been cut, and they are saying that the report says that only 18.
The affidavit by state of Assam. So
Yes, yes,
over the
it's an
fraud.
IEA. It's an IEA, my lord. Filed on 4th.
You got the IA.
My lord, I would request your lordships to have it on Monday.
It's not four-page IA, no?
No, my lord.
It's to
it's available.
initiate criminal proceedings against the applicants here. That's what it is for. Without showing your lordships a report. Your lordship solicited a
report
report.
is
No, it's not okay. The report specifically
What is
says
this, my lord?
we have found
Very
87 trees,
arrogant.
87 trees which have been
My lord,
chopped.
these are the applications.
And they say, however, because of the thicket, we can't go and count all the others. So it's 7 plus.
Allow me, my lord. My lord, these are the applications. The limited request is your lordships may go through it and have it tomorrow, have it on Monday, or my lord, tomorrow.
But the application for initiating proceedings is against them.
Yes.
Your lordships may go through it, my lord. I have made it.
But just tell us what is the
Yes,
ground?
my lord.
How would they do?
That's my lord the prayer.
Direct the Registrar General of this court to
If you
file a
don't mind,
criminal
Mr.
complaint
Gopal
against the
Subramaniam, can
appellant.
I argue? I know you will
But
be
he's not here.
misbehaving with me.
Mr. Subramaniam is not here.
But please don't.
Direct the Registrar General of this court
Lord,
to
your
file a
lordships.
criminal complaint.
Mr. Shankana, and between you, no personal remarks. Let's get on with
I
the
didn't say
matter.
anything.
No, my lord,
He called me Mr.
No, my lord,
Subramaniam. I'm just correcting him.
No, I'm sorry. That was,
I don't
I never
think you can
intended to
fault
insult you.
just.
All right.
Another insult.
Yes.
Well done.
I didn't want, my lord. It was, my lord, that's a mistake I always commit by. My lord, please see, my lord, page 3. Let us go through this one. Page 3. This was my reply on 22nd April.
Arpita will say.
Correct, my lord?
Actually, my lord, I had pointed out to your lordship that depending upon what
Now,
the
Mr.
report says,
Bhushan, you have done what you were asked to do.
if this
Let
joint
me
secretary has filed a false affidavit saying, now he has made 2 false statements clearly.
Let him move his application. Let's understand what the application is and we'll get back to you. Yes, Mr. Gupta.
My lord, para 5, page 3. My lord, this is what, my lord, my affidavit said.
Para 5.
Yes, my lord, my first affidavit says that it is submitted at the outset that there has been no felling of shade tree at the site in question. Further, there was no eviction of any persons or households from the land and the consideration, since the tract in question was not inhabited. The averments in the captioned appeals alleging felling of shade trees and eviction of persons are entirely inaccurate. As far as the removal of tea bushes is concerned, it is respectfully submitted that the same occurs routinely, even as a part of regular tea cultivation, and no prior environmental clearance is required for the same. The factual position in this regard stands corroborated by a letter dated 22nd April 24, issued by the State Environmental Impact Assessment Authority. A true copy is annexed. That it is further submitted that there has been no violation of notification dated so-and-so, since none of the activities described in clause 2 have been commenced on the proposed site of the airport project till date. It is affirmed that none of the said activities would be undertaken in regard to proposed category A project without prior environmental clearance from the central government. It is submitted that continuation of the Honorable Court's direction to maintain status quo would have the effect of stalling the environmental impact assessment for the project, which is not even the interim relief sought. My lord, thereafter, my lord, I have pointed out that the moment I raised the objection against Mr. Bhushan on 22nd, that some people staying 1300 kilometers away, based upon a self-serving report, files a petition, appeal. My lord, application comes. My lord, that's okay, my lord. Kindly, my lord, now come to my lord, page 7. My lord, page 7 may kindly be seen.
Yes.
Applicant respectfully states and submits that both the said facts narrated in the pleadings, my lord, that is pleadings of the applicant, appeal, my lord, before this honorable court are found to be false, as is evident from the report of the secretary. No 10,000 trees, but 89 shade trees were found to be cut. 4 of the statements recorded by the secretary to the authority categorically stated that he did not witness the cutting of any shade trees, while one person, namely Subhas Mirza, stated that some shade trees have been cut by some local people for cooking purposes. My lord, even the workers staying there, my lord, also cut the trees for, my lord, household purposes. One of the statements of Nilima Bumji, who incidentally happens to be an applicant in the subsequently filed intervention, and also other statements as well as report to the Secretary of the District Legal Services Authority, mentions that no eviction of any workers has taken place. My lord, this possibly persuaded your lordships to grant status quo. Now, my lord, what we are doing, my lord, kindly, my lord, if your lordships can go with me, I will not be as fast as your lordship.
Yes.
My lord, what we have done is, my lord, in a greenfield project, since the government, this is the northeast area, my lord, there was an airport which was a defense airport, which was being used for some commercial flights. Now the Defense Department Ministry has said that you have your own commercial airport for, my lord, various reasons. I will not go into it. So this is a greenfield project. My lord, the land was selected by the Airport Authority of India. because here land is not, my lord, just topography, but the wind direction, etc., has to be, my lord, seen. There were, I'm sorry.
Yes.
There were, my lord, three potential. Now listen to this, my lord, very carefully. There were three potential lands which were available for consideration. The examined all the three lands and selected this particular land. My lord, out of say 100 acres, my lord, I am giving a rough estimate, 70 acres was required, in which, my lord, no housing accommodation, my lord, was there. My lord, there were no hutments, etc. Lord, thereafter, airport authority said that for the purpose of runway, and I have said this on affidavit, we need a little larger land in which these hutments also come. So, my lord, the state government negotiated with the hutman dwellers. Now, kindly, my lord, see this. I'm sorry, my lord, sir.
But, Minister,
Can
the
I-
statements of the workers indicate tea bushes were uprooted from Dolo Tea Estate Airport site with the help of JCBs from the month of May 22.
By
And
the owner.
And within 3 days, it was uplifted. 200 to 250 numbers of JCBs were used day and night. The JCBs uprooted the tea bushes. The shade bushes were cut and uprooted as well, but I do not know the numbers of shade tree.
Kindly, my lord, if your lordships are reading somewhere else, my lord, I can't.
That is
Won't
our
be able to
report.
persuade you.
Report of the Secretary of the DLSA.
Can I, my lord, complete?
Yeah.
But if your lordships can, for the time being, not
Yes.
be with me. Lord, thereafter, when this was done by the earlier landowner. Lord, this is happening every year in every tea or coffee estate. But be that as it is. Lord, when the additional land came, my lord, came to be required by the airport authority.
Now, when was the origin? What is the status of the acquisition of the land?
So, my lord, the
It is
minister,
already-
minister says in his response to the question that the possession, in fact,
Always.
there's a letter dated, which is at page 55 of the petition. It's the government of Assam to the,
When was the land actually taken over by the?
yes, my lord, it's taken over on the 26th of April 2022. And the tea bushes are uprooted in May. After that, my lord, after taking over,
As the
325.
land was in Dolo Tea Estate.
Yes.
Dolo Tea Estate. Now, how has the land been acquired by the government of India? What is the agreement now?
No, my lord, it is acquired, my lord, by private negotiations.
What is the date of the agreement actually?
Lord, must be the date given by Mr. Bhushan.
Why doesn't everybody, your people have not stated the facts. The state government made the payment to the owner at a price decided mutually and scientifically. How much was paid?
Lord, that's not said because that's not the dispute here.
This was
Lord, I
335 acres.
Lord,
When was the agreement actually?
Lord, I stopped. That may not be relevant, my lord. I'll really assist your lordships if your lordship.
No, because if the agreement is before May 22, then the allegations that in May 22 they cut these.
Bushes, my lord, for which no permission is necessary.
That's not correct.
No, April they took over possession of the land. The
No,
Lord,
but
can your lordships not?
government took over.
But who
airport
took over
possession of the land.
Can your lordships not have, Lord, look at this and hear the
We are
matter?
reading that only. We are reading that. Actually, it's a short 12-page thing. We've already seen the affidavit. So you say that 335 hectares were initially acquired and thereafter 69 hectares for the purpose of the extension of the runway, etc. Therefore, you require 335 plus 69. Now, what we want to know is...
Only a minute more,
Yes.
my lord. Addition. Now, in view of the addition, my lord, of
Yes.
the land, the housing comes into the picture.
Right.
So the state government negotiated with the housing and said that we will shift you at a newly constructed quarter of which, my lord, photographs are annexed by me. My lord, please have a look at the photograph. They are, my lord, still in the process, but since there is a status quo, the officers, my lord, feel that we can't, my lord, page 92 onwards. And, my lord, therefore, including Mr. Gopal Shankar Narayan's client, everyone says that we are not uprooted. That statement of Mr. Bhushan was wrong.
Now see page 88, the photograph at page 88.
Page 80.
The Secretary of the District Legal Services Authority says that there is such dense vegetation that she was not able to move inside. She said because there would be snakes, there would
This is
be.
given by us, my lord, not by her. These are placed by me to show
Right.
that these are bushes, not trees.
But she says in a report that there is dense vegetation.
My lord, dense forest. My lord, she says dense forest. There was a snake. My lord, in every tea estate there are snakes.
But she says there is a dense forest, she says.
My lord, this is the
She's
photograph.
Yes, LSA. She's a district judge.
My lord, no, she's not, but that apart. My lord, kindly see, my lord, she treats this as a forest. My lord, these are bushes.
But
Your
Mr.
lordship can
Solicitor-
ask her, my lord, what is her definition of forest?
No, but Mr. Solicitor, you have also given, if you annex just one photograph and say that, well, there's no dense vegetation here. We will go by what she has said.
I have to be proved wrong, my lord, I have nothing more to
No,
say.
but just see
So
what
I
she has
wanted
said.
to show how your lordships were misled. My lord, if your lordship feels that the state is misleading and this, my lord, people staying at 1300 kilometers are right, I have nothing to say, my lord.
We have our own judicial officer who's a
She
judge
is-
there.
Lord, bushes, she can't enter and she says dense forest. What can I do, my lord? She treats, my lord, bushes as forest.
See, 1 second. See
Page
page
84, my lord, please see page 84.
Page 27. Page 27. This
Lord,
is her
I think,
report.
my lord, I never knew, my lord, intervention would come and my affidavit, my application, my lord, possibly was a strategic mistake. I don't wish to prosecute them.
1 second.
Kindly, my lord, have a
1
look at
second
the
now.
matter
1
of
second.
where this is.
We will not go by anything else. We appointed her. She's a judge. We appointed a district judge level officer to go to the site and examine it.
Correct, my lord.
We trust our own because they have no axe to grind. We trust our own
We
officer.
also have no.
She may be right, she may be wrong, but she's bona fide. So now she goes to the site and see page 26, her report at page 27.
Well, kindly see
We could not
84.
proceed much into the site as it is a dense forest as present, inhabited by poisonous snakes and wild insects. The bushes were too thick to be removed by hand and feet and proceed ahead.
My lord, would your lordship see page 84, the photograph? This is what, my lord, this is her photograph, which she describes as a forest. My lord, I confine myself to this application, not to interveners, but let it be confined to the petitioner, my lord, appellant. Let us, my lord, focus, my lord, on the issue in question, that your lordships were misled by the so-called PIL petitioners. That's my case, my lord.
So now, my Lord, may I say something?
Let me complete, Mr. Bhushan. You're done. You said what was recorded by the court. And now it is finding, it's found to be false.
Now at your report, please see page 44. Page 44 of your affidavit.
Yes, my lord. And, my lord, I still
Just see
stand,
page 44.
my lord, I still stand by this, my lord, that till the permission is
At page
granted.
44,
Yes, my
the
lord.
tea bushes were uprooted from Dolo to East State Airport site with the help of JCBs from the month of May 2022. Within
Correct.
3 days, it was uplifted. 200 to 250 numbers of JCBs were used, and day and night, the JCBs uprooted the tea bushes. Shade trees were cut and uprooted as well, but I do not know the number. This is,
In fact, my Lord,
My lord, kindly see, my lord,
The-
page 31. Page
The-
31.
the person, my Lord, in
Wait, now,
charge
please,
of,
Mr. Bhushan, you are, I can understand Mr. Shankar Narayan arguing. Don't do, you don't argue. You are staying at 1300 kilometers and your so-called people say, "Look, this is clearly at the behest of somebody else who wanted his land to be taken. Well, this so-called report says that that land is better. I'm not going into it. Well, please come to 32. Page, well, at 35.
yes.
On oath, my name and address is so and so, so and so. We will be shifted. Yeah. We have not been evicted yet, my lord. We will be shifted in section of Dolo Tea Estate, but the new houses built are very small in size, etc. my lord. Lord,
You will say now, hereafter, the no steps will be taken until the environmental clearance.
correct, my lord. I've said on affidavit, my lord. I've said on affidavit, but what about a false statement that 10,000 trees are evicted and people are being, uprooted and people are being evicted. My lord, please see the photograph, page 79, new houses are being built. I have filed an affidavit that they would be shifted in new houses. Page 79, my lord, please see the photograph. This is stayed because of the status quo, my lord, which Mr. Bhushan got. But this is how, my lord, your lordship's jurisdiction is being abused. And please see, my lord, now that so-called report, the so-called experts, my lord, have not even visited the site and they certify that some other land, who possibly is the man behind this litigation, my lord, that land is a better land. Well, your lordships will have to take that into consideration.
So, Lord, may I now have a few words before the learned solicitor?
Lord, would your lordships Lord,
Yes.
page
May
36, for my satisfaction, page 36.
Yeah.
The same statement which I was reading, my lord. Out of 173 families to be evicted and assured to be given new houses, 25 to 30 families have not been allotted any new houses. Shade trees have been cut by some local people for cooking purposes, while some have been uprooted by storm. We do not have gas stoves or gas cylinders to cook. Shade trees are also cut for cooking by some people. 89, not 10,000, my lord. Then further, these activities are mainly done at night. So I cannot tell who has cut the trees, etc. My lord, when the government cuts, my lord, they don't cut, my lord, randomly 89 trees, but they start with the beginning. And my lord, please see 79, my lord, new houses are being constructed. A genuine bona fide appellant, my lord, who is a public spirited man, would show this when telling your lordships that they have been uprooted, that they are not being uprooted. They have been paid money also, and my lord, this also, that they are being given alternative new accommodations. But I stand by what affidavit I filed on the first day, that till the permission is granted, my lord, please see, my lord, that my lord, the notification at page, my lord. My lord, another thing, my lord, my learned friend also relied upon some exchange of question answer in the Parliament Assembly. That
Yes.
minister said that 10,000 trees. My lord, I have produced a certified copy of the question answer signed by the Secretary of Legislative Assembly. What was asked was how many bushes are cut, not trees. Please come to, my lord, page 218. My lord, this is that concern notification. My lord, with which your lordships are rightly concerned, and my lord, I am bound by it. 218, my lords. Lord, can I?
Yeah.
Am I with your lordships at 218?
Yeah.
Appeal. I'm sorry, your lordships were reading 218.
No?
Just the schedule. Two, my lord, I'm sorry, 2. Well, this is the notification dated 14 September 2006. Your lordship gets one. Lord, at page 218, 2, requirement of prior environmental clearance, the following projects or activities shall require prior environmental clearance from the concerned regulatory authority, which shall hereinafter refer to as the central government in the Ministry of Environment and Forest for matters falling under category A in schedule, and state level, the state impact assessment authority for matters falling under category B of the schedule, before any construction work or preparation of land by the project management, except for securing the land is started on the project and activities. 233 is the airport. Page 233.
Airports.
Yes.
Yes. Yes.
Now, your lordships, my lord, kindly come to, my lord, my earlier affidavit. But I stand bound by this, my lord. My earlier affidavit, my lord, where I have placed, my lord, on record a certificate of, my lord, at page 5. My lord, my affidavit dated 22nd April 24. The lordship gets, my lord. Inviting reference to the subject cited above, this is to inform you that the matter has been referred by Special Chief Secretary, Environment and Forest, Assam, inviting comments or opinion as to the requirement of prior environmental clearance for clearing of tea bushes, uprooting, removal of shade, cover crops in respect of Dolo Tea Estate. On careful perusal of the averments made in the instant petition, it is to be stated herein that cultivation of tea in Assam is falling within the category of special cultivation, for which the government of Assam district commissioner allot land within the ambit of rules under so and so. It is pertinent to point out here that in the tea garden, tea bushes and shade trees are removed and uprooted in regular intervals once the trees grow old and there is loss of production of tea. Generally, Cyrus tree species, which are fast-growing indigenous species of trees in Assam, are planted as shade trees, cover crops, and primarily used to meet the requirement of fuel wood for workers in the tea gardens. As per the Assam Tea Garden Act or policy, clearing of tea bushes and shade trees are permissible. Moreover, we have not cut any shade tree. I make that statement, except the 89 trees, which, my lord, one of the statement giver, my lord, says that must have been cut for the purpose of my lord, food, I mean, fire cooking purpose. Cooking purpose. And something wrong. You are hiking. But if your lordship so feels, even that will not be done. Well, let the project not get stalled at the behest of someone.
Say that no steps now should be taken without the environment clearance.
Correct.
All that we'll say, and we'll conclude the matter.
Just one thing I
So that hereafter they must have an EC before anything is done. That's what we have to do.
Operatively, your lordship is right. That would be the right thing to do. I'm just pointing out that my learned friend went on and on and on, accusing us and so on. Now, I just want to point
I have not completed accusing.
Two very clear false
There are several things to show.
in the affidavit.
What must know about it?
Yes. One first statement is no shade trees were cut according to them. Second wrong statement is that tea bushes were uprooted by the garden as part of routine clearance. These are the two statements. Now just see the report, internal page 5 of that report. At the bottom. That is in the PDF, I think, my lord, it is page 469, probably. At the bottom.
Can my learned friend say, who is he?
It says, thereafter, in the office of the Dolo Tea Estate, the statement of the Garden Babu was recorded and his statement has been annexed. As stated by the manager in his statement, the office contains no documents for planting of shade trees. Hence, the Garden Babu verbally stated that the shade trees planted in the proposed airport site were planted following the 40 feet by 40 feet rule in the 325 hectares of the airport site land. Now, pausing here. I have done a very quick calculation. 325 hectares is roughly equal to 21 lakh square feet. Sorry, it's equal to some 340 lakh square feet or something like that. You divided this 40 feet by 40 feet, he says. That is 1600 square feet per shade tree. 40 feet by 40 feet, 1600. You divide it by 1600, it comes to more than 21,000 shade trees in that 325 hectares of land. That is why 41 lakh tea bushes, 41 lakh tea bushes have been uprooted. And it was a bulldozer operation, as your lordship pointed out, of more than 200 earth-moving bulldozers who worked day and night to clear this land.
Where does he get
So
all these
obviously,
figures?
when they cleared this land, this was 2 years ago. When they cleared this land and removed all the tea bushes, obviously they removed all the shade trees also. And the shade trees, which should have been in 325 hectares on a 40 by 40 rule, as he says, would have been something like 21,000 plus shade trees. Now, obviously, after 2 years, you won't find most of these shade trees lying there. They have all been removed. So therefore, it's clear from these statements that 41 lakh
You place photographs of
1
the
lakh
shade
tree
trees.
bushes, uprooting of 41 lakh tree bushes is admitted. The uprooting was done in May. The possession of the land for the purpose of this airport was taken 1 month prior to that in April. So obviously this operation of removing 41 lakh tea bushes was not done by the tea garden. It was obviously done by the authorities for clearing it for the purpose of this airport. So therefore, two clearly false statements were made in the affidavit of the Joint Secretary. One, that no shade trees were removed, and two, that the tea bushes were routinely removed for the purpose of the tea garden. Obviously, they were not routinely removed. They were removed after possession had been taken by the authorities in April. And that letter, my lord, of taking possession is at page 55 of the original petition. It says, sir, I am directed to inform you that the Deputy Commissioner has passed the necessary order for allotment of 2,500 biga land for the proposed Greenfield Airport, etc. You are kindly requested to depute authorized representative of Airport Authority for taking over possession of the land on 26/4/22 at site Silchar and may kindly be intimated. So they took over possession on 26th April 22, and the clearance of this with the use of more than 200 bulldozers was done in May, and all the news reports which we have annexed, very large number of news reports, all are dated that 12th, 13th, 14th May, etc., all showing photographs of this huge number of bulldozers standing there for the removal of these trees, etc. So therefore, they have done something very serious. Apart from violating the environment protection, even in fact, social impact assessment needed to be done. And these people who are the workers there, they may not have been living at this particular site, but they are clearly people who were working there and who have been affected. Under the new Land Acquisition Act, they are affected persons. Thousands of workers are there.
That's not an issue. You raised you
Lords,
the appeal.
I'll just take 1 minute, just 1 minute. Just three quick points. One is that at the bottom of page 6, Mr. Bhushan was reading the statement of the district judge. As per statement of concerned circle officer so-and-so, 41 lakh 95,909 numbers of tea bushes have been uprooted.
Where do you get that?
That's at the bottom of page 6 of the report,
As
of the inspection report.
31, page
As
30.
per statement of the concerned circle.
Page
Page
6.
31 of my affidavit, which I tendered today.
No, we have to go by the report. I'm only going by the report. I'm not going by
Next,
ipsi dixits of officers.
it's
Page 6
Total
of
89 numbers of shade trees that been found to be cut.
Below that.
He is unnecessarily.
Two-line
saying if it-
paragraph says, as per the statement of the concerned.
Last but one
second
paragraph.
last sentence.
Last,
Yes, as per the
That's the report.
So and so.
41 lakh 95,909.
I have re
Yes,
That's all.
that's of the tea bushes have been uprooted. Now that's an unequivocal statement. This is one aspect, tea bushes. The other were the trees. All those trees which add up to 87. She keeps saying, look, I have found 87. There may be more, I don't know, but there is too much foliage. I can't go through dense forest,
They
snakes,
won't
etc.
be lying around for 2
Now,
years.
The second thing is, if you see the environmental clearance form, which has to be submitted with the environment clearance, the form clearly requires clearance of existing land, vegetation and buildings. They're supposed to fill it up. Throughout, the phrase that's used is trees and vegetation. So trying to say that, look, trees, we don't know, somebody chopped a few trees for cooking, and 41 lakh bushes going. There's a huge gap because those bushes form part of this form for which you have to get clearance, prior environmental clearance. There's no question of chopping it and thereafter coming and saying, look, why are you complaining? You're 1,300 kilometers away to him. And as far as I'm concerned, there must be some other objection as far as I'm concerned. But there's no explanation why 41 lakh bushes went. Third, I don't know about Gujarati tea, but as far as Kerala tea is concerned, we are very familiar with how tea bushes function. Nobody uproots and destroys trees. One or two which are decayed and dead maybe. 41 lakh bushes.
I'll not be
tea
as
bushes.
childish as-
It's not a practice anywhere. It's not a practice anywhere to uproot tea bushes because that's what they've stated on affidavit. Finally, the learned solicitor relied on his short affidavit. His short affidavit annexes that document which was read out to you. This short affidavit which was relied upon. I find it a little surprising.
Expected.
I find it a little surprising that this document which was relied upon to show your lordships was dated 22nd April. Lordship, see that? The document which was just read out fully to you.
Yes.
The date on that is 22nd April at the top. Below the member secretaries.
Just 1 second, wait. We'll just go to that in a moment.
Yes, that's page 5 of his short affidavit dated 22nd April 20.
It's 22nd of April, right?
Yes, yes.
And
You see that document, that annexure? It's
Yes.
22nd April at the
Yes.
top. At the bottom, under member secretary's signature is 22nd April.
yes,
The affidavit on the previous page is signed 22nd April. It was shown to your lordships when your lordship passed the last order, which surprise, surprise, was 22nd April. I find it very strange how it's a self-serving document which has been conjured by the government on 22nd April, filed by an affidavit on 22nd April, flashed before your lordships on 22nd April, and all of this is supposed to be relied upon by them to get around this glaring fact. And now they question locus. Locus is their strongest point, really. These people were parties before the NGT. This is an appeal before you. This is not some writ petition.
well, I admit this appeal arises from an order dated 25 January 2024 of the Eastern Zonal Bench of the National Green Tribunal. Full stop. The appellants moved the, before that you can say, the Ministry of Civil Aviation of the Union Government decided to build a commercial airport at Silchar in Assam, since the existing defense airport was not suitable for domestic civilian operations. 3 estates, after identifying 3 estates, namely, इनके काउंटर में मिलेगा page 11, Dolu, 2 Koril and Silkori, and 3 Silkori. Don't say after. Three key states, namely Dolu, Kuril, and Silkori, were identified by the government of Assam. The Airports Authority of India conducted a feasibility study and identified Dulu as the site for a new greenfield project, a new greenfield airport on land admeasuring approximately 335 hectares. Good stop. The Airports Authority, AAI made a request for additional land, following which an adjacent area in the same T state admeasuring 69 hectares was identified. Stop. About 173 dwelling units are situated on the additional area of 69 hectares. Good stop. The appellants moved the National Green Tribunal with a grievance that that despite so in terms of the notification dated 14 September 2006, an environment clearance was required, the site, the notification dated 14 September 2006 of the Ministry of Environment and Forests, an environment clearance was required, the site had been cleared of shade trees and tea bushes in the absence of such a clearance. Full stop. The NGT, by its order dated 25 January 2024, dismissed the OA holding that the environmental impact assessment report was awaited and the environmental clearance for the airport has not been granted, and hence the plea of the appellants for an order of restraint on the grant of site clearances and in principle approvals was without merit at that stage. Let's stop. When the petition was taken up by this court on date on 22 April 2024, it was an admitted position that an environmental clearance is required for the project of setting up the airport, and no such clearance had been issued. Full stop. Paragraph 2 of the EIA of the notification dated 14 September 2006 is in the following terms. The main paper book mein para 2 copy kar lijiye, PDF page 247 ko. Last order. Yeah, apne last order mein bhi hai wo. Dated 22 April 2024, the Secretary of the District Legal Services Authority, Kachar, was directed to visit the site and submit a report to this court on bracket 1, whether any felling of shade trees had taken place. 2, whether any eviction at the site has taken place. And 3, the nature of the activities which have been carried out at the site. Next. At this stage, it would be material to note that contrary to the assertions of the petitioners, contrary to the assertions of the petitioners, on 22 April 2024, an affidavit was filed by the Joint Secretary to the Government of Assam in the General Administration Department
Para 4.
stating that into invert commas, that there has been no felling of shade trees at the site in question, into invert commas complete, no eviction of individuals or households had taken place from the land under consideration, since the tract was not inhabited, and that the removal of tea bushes, into invert commas, occurs routinely, even as a part of regular tea cultivation, into invert commas complete, for which no environmental clearance is required. Full stop. The affidavit contained an annexure, which was a letter dated 22 April 2024, into brackets, issued on the same date as the affidavit, bracket, by the Member Secretary of the State Environment Impact Assessment Authority, Assam, to the Member Secretary SEIAA in the following terms, colon, ये additional paper book में आपको letter मिलेगा, ये पूरा copy करना है, छोटा सा letter है, page 244 पे है, 244. Next. In pursuance of the direction of this court, Ms. MS Salma Sultana, a judicial officer in the state of Assam, who is posted as secretary in the District Legal Services Authority, Kachar, has submitted a report dated 27 April 2024. The affidavit inter alia indicates that she and her inspecting team, consisting of the members of her staff, found that a total number of 89 shade trees to have been cut
Were found.
were found to be cut. But stop the Ms. Sultana has also stated that, into invert commas, the entire area is mostly a dense forest. Therefore, other possible cut down shade trees were not visible due to dense forest and thick bushes. ये आपको मिलेगा काउंटर में पेज 31 पे. The secretary of the DLSA has also indicated that, according to the statement of the circle officer, Sri Arun Jyoti Das, 41,95,909 tea bushes have been uprooted. Next.
One new fact which has brought science. But we took possession on 18th June 22. This possibly would have happened in May 20.
The report of the Secretary of the DSLSA,
I have the order.
the Secretary of the DSLSA has recorded the statements on oath of several witnesses who were workers, who were, as the case may be, tea garden workers,
Garden Babu,
the garden manager, circle officer, and Patwari, among other persons. But several witnesses who were examined by these officer appointed by this court have stated that tea bushes were uprooted from Dolo Tea Estate airport site with the help of JCBs in the month of May 2022. And the entire operation, which took place over 3 days, involved the use of about 200 to 250 JCBs day and night. The witnesses have stated that shade trees were cut and uprooted as well. The court must take cognizance of the fact that the statements of these witnesses have not been tested on the anvil of cross-examination. At the same time, at this stage, it would prima facie appear that a substantial amount of that these statements would match with the statement of the circle officer to the effect that 41,95,905 tea bushes have been uprooted. As you have already noted, the contention of the state government in the affidavit, which was tendered before this court on 22 April 2024, was that tea bushes are removed routinely, into invert commas, even as a part of regular tea cultivation, into invert commas complete, for which no prior environment clearance is required. To support this submission, reliance was placed on the communication of the member secretary of the SEAC in Assam, which also records that in a tea garden, tea bushes and shade trees are removed and uprooted at regular intervals. Once the trees grow old and there is a loss of production of tea. What, however, needs to be noted is that in the present case, the clearance of the site was by no means traceable to the cultivation of the tea estate. The clearance was evidently not as a part of the regular maintenance of the tea estate. Paragraph 2 of the notification dated 14 September 2006 requires a prior environmental clearance, into inverted commas, before any construction work or preparation of land by the project management is carried out, except for the securing of land. Full stop. The nature of the activities which were carried out at the site were evidently of an extensive nature and would appear to be in breach of paragraph 2 of the notification. Full stop. In this backdrop, we have come to the conclusion that there was a complete abdication of duties, of adjudicatory duties by the National Green Tribunal. Full stop. As an expert body which has been formed under a statute enacted by Parliament, in the interests of the preservation of the environment, it was first and foremost the duty of the tribunal to verify the authenticity of the grievance of the appellants. Full stop. The tribunal, however, simply dismissed the OA, having come to the conclusion that no environment clearance had been issued. Full stop. If the tribunal were to inquire into the matter, even at a prima facie, even on a prima facie assessment, the facts which have emerged before this court would have come on the record. Full stop. The state government has filed an application for directions before this court, seeking the initiation of proceedings against the petitioners for having misled this court into passing its order dated 22 April 2024. During the course of the hearing, during the course of the hearing, the Learned Solicitor General has stated that the application is not being pressed. Full stop. However, full stop. From the material which has been placed on the record, we are clearly of the view that the authorities in the present case have acted in violation of the provisions contained in para 2 of the notification dated 14 September 2006 by carrying out an extensive clearance at the site, even in the absence of an environment clearance. Full stop. Undoubtedly, full stop. The state government has has emphasized the need for establishing a civilian airport at Silchar, which has led to the proposal to set up a greenfield airport on land admeasuring 335 hectares, to which an additional component of 69 hectares has been added. Full stop. It is not necessary, full stop. The decision on whether an airport should be situated at a particular place is undoubtedly a matter of policy. Full stop. However, when the law prescribes specific norms for carrying out activities requiring an environmental clearance, the provisions of the law have to be duly complied with. Full stop. Setting up an airport is specifically within the ambit of entry 7, bracket A of the schedule to the notification dated 14 September 2006. Admittedly, no environment clearance has been issued until date. Next, in the above view of the matter, we allow the appeal and set aside the impugned order of the National Green Tribunal dated 25 January 2024. Full stop. In consequence, there shall be a direction that absolutely no activity shall hereafter be carried, that absolutely no activity shall be carried out in breach of the provisions of the notification dated 14 September 2006. Let's stop. That's all that we, that's all. That's all.
They have actually
Only one
destroyed
request.
41 lakh trees, this bushes, tea bushes, 41 lakh tea bushes. And we have filed scientific reports showing how much carbon is sequestered by one tea bush in a year. It's enormous. Actually,
And I have to say many
41
things on
lakh
that
tea
independent
bushes
report.
would cause environmental havoc, uprooting 21 lakh, 41 lakh tea bushes. Because
Only one
The
request.
application for the grant of environmental clearance shall be processed on the basis of the position as it stood prior to
It's not
the.
been filed, Manoj.
No, no, no.
As of March, an RTA tells us they haven't submitted. I don't know if they have
No, we'll
submitted.
say that the processing of
Whenever-
If they file.
in the event that any application for the grant of environmental clearance has been filed, or if it is filed hereafter, the processing of the application shall take place on the basis of the condition of the site as it existed prior to the date on which the illegal clearance of the tea bushes and shade trees took place in the proposed site of the Greenfield Depot.
we are very grateful, my lord. This is
Yes.
very
Actually,
remarkable. that
permits,
the
Lord, I
court-
can say something. And Mr. Shankar Narayan permits, Lord. Lord, two things. A, your lordship says nothing to be done. If your lordship can clarify, except construction of those, Lord, quarters, labor quarters, which it's going on.
This is going on in another location. Where is
In
the
the
site?
land, my lord,
No, it's in the same line.
in the same land,
In the same land.
in the same.
They need the EC before they go ahead with anything. Otherwise, it's pointless.
Lord, they are staying in huts, my lord, it's for them.
They haven't evicted yet. So
Yeah, but that's what the.
So should we allow this construction of those quarters for the
Lord, he said it,
173
we are
workers?
already
I think, Lord,
evicted.
everything should be
Mr.
stopped for the
Bhushan
time
says
being.
they are
For the
already
time
evicted
being,
according to
everything-
Mr.
because
Bhushan.
That is on the assumption that they will
Can't
succeed
argue on assumption.
in getting environmental clearance, etc.
Technically, if we now allow any construction, that will be, we will be breaching the order.
Yes.
We can't really, we can't.
Another-
Because otherwise we will be, by judicial order, we will be violating the notification.
It was, my lord, a strategic mistake to file this application without knowing, my lord, the interveners, my lord. I took possession, my lord, on 18th June 22. Your lordships have, my lord, recorded that we have removed the
Totally,
bushes, my lord.
totally
But-
false statement again. I can demonstrate from the district magistrate's order, from the letter of the government, etc., that the possession was taken in April and this whole clearance activity took
Lord,
place.
I
in
can
May.
show that, Lord, I don't want to
District
join issues with
magistrate
Mr.
passed
Bhushan.
an order.
144.
Yes, 140.
When was the date of the 144 order?
April, I'll just show.
Yes, my lord,
No,
but we
May.
got it in
May.
June, my lord.
in which case there should be an
I just
investigation. If they got
Because
it in June, whoever did this should be investigated. Because it's clearly not the government.
That's, my lord, my mistake. strategic
order is
mistake.
of
I
11th
never knew
May.
Mr.
11th
Shankar Narayan
May
would
is
be
the
appearing, otherwise I would not have filed it.
Of the, just on the day when the JCBs were moved there, on that day,
Is the 11th May order on the record?
yes,
Yes, yes.
It's at page 57 of the paper book. Page 57,
My lord, I'm sorry, my lord,
annexure P6 of the petition.
So it then dovetails with the statement to the workers that the clearance took place in May.
Yes, yes.
So there's a 144 order and then they went and cleared the site.
would your lordship.
All the news report, there are 10
If your
news
lordship
reports
see this, if your lordship.
with
my lord,
photographs.
Let us see that. What is that?
It is June. We were handed over the possession in June.
Police and CRPF were posted there on 13th May.
I leave it at that. So your lordships have recorded a statement that
This
we
will be
removed.
handing over the site by the government of Assam to the airports authority.
We have annexed the letter, my lord, Annexa
By
P5.
to the transport authority.
The transport
That's
authority.
internal.
But it appears that the clearance took place. That's the purpose of the 144 order, because otherwise these people would have protested the site.
I leave it at that. I leave it at that.
11th.
Grateful.
I'll give.
Allow kar do.
Anyway, my lord, I don't wish to say anything. Only one thing. I
Yes.
invite my learned friend for a cup of tea. Gujarat do not cultivate tea, but
I prefer
Gujarat
coffee.
is very effective and strong. I am not that effective and
I'll
strong.
happily
but
accept that.
Gujarat tea is effective and strong, and you know that.
This is one case, my lord, which your lordship have dealt with from A to Z with such exemplary promptitude. It's remarkable.
Now, your lordships may have noticed from the final line in the impugned order that the petitioner the High Court has retained the
The petition
matter,
is still pending.
has kept the matter, but for all intents and purposes it is disposed of. And
Says show cause notice to.
the show cause notice was so atrocious as noticed by the High Court that the SRA withdrew the show cause notice. After the impugned order is
Now,
passed, they
there is
issued a fresh
there
show
is
cause
joint
notice.
venture between the SRA and the
MMRDA. And it's just, if this were in the realm of tort, this would be procurement of a breach of contract. We are in administrative law,
It's a slum.
so therefore this is entirely colorable.
It's a slum.
I have,
It's
sorry,
a notified slum.
it's a notified
You
slum.
have an NOC, you are the builder
Yes,
appointed.
so there are LOIs most recently, which has been extended in January 2023. Most recently, it's been going on. 1,000 slum dwellers are already rehoused in rehabilitation towers which have come up. So those towers have come up. There's one free sale tower which has also come up.
But the High Court says that there is a default on your part. So they
The High Court doesn't. Let me just indicate what has
They have
happened.
said that, at least give them an opportunity to show cause.
No, but the High Court, I want to therefore.
Your contention was because there is a joint venture, so-called JV between MMRDA and SRA.
Quite so.
Therefore, don't even adjudicate upon my default until.
Don't at least show there's a limit to how gullible courts should be. So I am respectfully saying, let me see the documents. Let me show you the documents. Please note the dates.
So just one thing, a
Please
show
note
cause
the
notice
dates.
has now been issued on 30th of April.
I'm the SRA. Can I speak?
Now,
Show cause notice has been issued to them on 30th April where all parties are to be heard.
MMRDA.
I'm for respondents.
I am SRA.
I'm for respondents 4 and 5, the
That is-
landowners. I'm just pointing out factually.
Who's R4 and R5?
Now a show cause notice has been issued.
R4 and R5 is whom?
The landowners, 4 and 5.
Can I just, I am the SRA.
The developer.
I issue a detailed notice to him. He is yet to reply. His prayer is
can we just
stop
make
him
our
from giving.
submission now, yeah?
We'll hear them.
Now just let me indicate what has happened here.
When you went to the High Court,
Yes.
what have you actually challenged?
I'll tell your lordships. This is, as the opening paragraph of the impugned judgment indicates, this was the second time we went to the High Court.
Right.
The first time we went to the High Court, they said, look, what's your cause of action, etc. Now, meanwhile, the prayer in my writ petition was inter alia in respect of that show cause notice which the SRA withdrew. So to that extent, you lordship recalls that there is a show cause notice which has been adversely commented upon in the impugned judgment itself, saying that we can't make head or tail of this. And then Mr. Dwarkadas appearing for the SRA withdrew
Patel said that it was a grey on black or something like that.
So anyway, so SRA withdrew the show cause notice. Now what happens now? But that doesn't still solve the issue and it doesn't examine the issue. Now what's the issue? we have a series of letters of intent which have been going on. As I indicated to the court,
When is the original letter of intent? In
the original was it's a huge, massive area, my lord. It's 2 lakh square meters, out of which the initial one was in 2009. The most recent renewal is January 2009. Now, 2023, I'm sorry, 2023. Now, I want you to go to page 288. Please go to page 288, annexure P15. Annexure P15. Now, this is a document of 26 September 2023. Your lordships have P15. I understand it's PDF 331.
Yes, we got it.
Your lordship has it. Now, please see the subject. Extension of Eastern Freeway through Ramabai Nagar, Ghatkopari. So, we are Ramabai Nagar. A meeting was held under the chairmanship of MMRDA at so-and-so, 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 following were present. So you have the municipal corporation present, traffic commissioner, SRA is present, collector is present, chief engineer, MMRDA, everybody is present. Now they have a expressway which is going through this. Now please go directly to clause 8 of these minutes. Clause 8 of these minutes, print page 291. Your lordship may start, in fact, at the top of the page, see clause 6. CEO SRA agreed to coordinate with both the collector and developer, Messrs. Neelam, regarding the issuance of a LOI for both the lands, including collector MSD land. Your lordship has that? So they're all present. Now see clause 8. CEO SRA agreed to issue a letter of intent to the developer for the development of the entire land upon receiving a proposal from the developer. The developer needs to vacate the land for road construction immediately and hand it over to the SRA, and will then hand it over to the MMRDA for road construction. The collector of Mumbai suburban districts agreed to issue an NOC required with regard to MMRDA. Now look at 12. As MMRDA is an advanced stage of tendering, therefore SRA agreed to provide a timeline for the process and land and hand over the MMRDA to initiate road work. So everything until 26 September 2023 is absolutely hunky-dory. Of course, we realize that the expressway has to be constructed. It has to be given so MMRDA can construct the... Then what happened was, in January, certain brochures started floating around with regard to some grand project. Now, please see, just have a look at page 387. Just go to 387. Now, 387 is a document which is issued sometime around February 2024. PDF, page 430, annexure P21. Now, the whole thing has suddenly changed. So, please see what's happened. Your lordships have annexure P21, notice inviting extension of expression of interest. Your lordship has that. Now, see this. In principle, sanction for provision of a rupee denominated loan of up to 4,000 crores to the MMRDA for the development of a slum rehabilitation project in Ramabai, Ambedkar Nagar, Ghatkopar East, etc. So they are now asking for an expression of interest because they need 4,000 crores, not for the expressway, but for the slum rehabilitation project. So this is sometime, if going by the dates here, February 5th February 2024. And if your lordship is pleased to just turn a few pages later, you will find at the page 394 printed, which is 438. 437, 394. 437. Please see current proposal at the foot of page 394. The Ramabai redevelopment project is a collaborative effort between two government organizations, MMRDA and the SRA, under the supervision of the government of Maharashtra. Your lordship has that?
Yes.
Correct? GOM. This initiative is vital for the sustainable growth to Mumbai, etc. The plan involves redeveloping a 30-hectare slum area with the current inhabitants being relocated. So the whole, and please go to the foot of the page when you will see a table. And against sponsor, promoter, you will find MMRDA and SRA in the table.
Right.
So this project, which is I am implementing, towers have come up LOI is issued. September 2023, we have a meeting where they say, yes, as far as the expressway, it will come.
Now,
All of a sudden,
LOI to you covers what extent of the area?
so the LOI, yes, so just let me tell you, the LOI today covers, now Melons, I'll just give you a figure. It covers 62,397.07 square meters out of 62,397.07 square meters out of
6290
a larger area of approximately 1,98,000 square meters. You may take a round figure of 2 lakh square meters. Now, out of this 62,397 square meters, please note that a section of 18,100 square meters is substantially, I will say substantially implemented. That means huge number of towers have come up, including a free sale. I have a photograph if your lordship would like to see it. Free sale components, etc. And 1,000 slum dwellers are already rehoused in this smaller area of 18,100 square meters. Out of total of 62,397.
Now, what is the date of the original LOI in your favor?
I found that it was the original was 2009, I think. The earliest one. But I gave your lordship the recent one is 30th January 23. The current one is 30th January 2023. Then September, this renewal, etc. takes place. Now, in a situation such as this, now please see one last page, which is annexure P22, which is, I think, page 443 PDF. Yes. Correct.
Now they say
Now,
MMRDA,
your lordship has
SRA
this
join.
announcement. Mumbai MMRDA SRA joins hands to redevelop 15,000 slums in Ghatkopar. Your lordships have that
Yes.
heading. And then you will feel that there are several high dignitaries, etc., which are mentioned. And this entire project is sewn up behind my back without a Section 13 process being followed as far as I am concerned. So our point
You have never been removed as a developer.
that's what the show cause notice now is for. So we said, what is this? This is all premeditated. This is, and SRA and MMRDA are the joint, your lordship saw that. They are the project proponents now.
So what the division bench of the High Court
So
now
what the
does is
division bench
they've
does-
kept the petition pending.
It's kept the
They have
petition
given them
pending.
liberty to give you a notice to show cause.
And and there is a gratuitous paragraph over there which says that, oh, the SRA, because here he's acting as a promoter, that you will act, SRA, you will act only as in your capacity as a planning authority, and you will hear them and you will ignore MMRDA. Now the SRA chair, after all this which I have showed your lordships at para 400, what is it? It's premeditated what he's going to decide. So in my respectful submission, this is all completely choreographed. It's completely choreographed.
LOD number.
See, one last
What we were
yes,
thinking
sir.
of this, let's put our, so I think that will cut through the matter. Obviously now, SRA and MMRDA, as the brochure indicates, were proposing to develop this land together. Let me place your case at the highest that there were defaults on their part. They have a legitimate grievance that, look, if SRA is now going to develop it with MMRDA. Where is the question of a show cause notice to me being adjudicated upon by SRA? What we were suggesting was this. Let an officer of the state government to be nominated by the chief secretary who has no association either with MMRDA or SRA.
Can I
Adjudicate upon the show cause.
Retired justice,
I've heard my
Retired justice, these are, matters where,
now allow me to.
And
Your
one
lordship.
second. We are not going to say, because if we say no show cause notice, then in spite of his defaults, he continues. That then giving specific performance.
Your lordship, I just hear you.
What we can do is this. Show cause notice, we will not stultify the adjudication of a notice. But let it be adjudicated upon by an officer of the state government who is independent of MMRDA as well as SRA.
Therefore, before your lordship, your lordship is prima facie, I said something. Allow me just 3 or 4 minutes. And if your lordship at all wants to touch this matter at all, how frivolous and luxuriously obstructive it is. I've used those words advisedly. Give me 2 minutes. Before I come to the law, just turn to one interesting.
For whom? MMRDA?
No, SRA. Number 2, R2. Just see what he has done.
All right, so let me just
15.
complete.
Dr. Singhvi, 1 second.
Come to 15.
1 second. SRA gave him a letter of intent in 2000.
That's right. Just see what he did with it.
How can you
Because of what he has
advertise a
done,
project without
hasn't-
terminating him?
He hasn't told your lordship what he has done. Give me just 5 minutes.
All right, so then I'll just
Allow
complete
me now,
one
please.
document. One document.
That's all I
All right, very well.
Yes.
I want less than 3 or 4 minutes for this.
Yes.
Please turn to page 15. 1-5.
What did he do?
The learned judge has Balus the plan. This is not told to give 3 copies. Yes, just give.
Yes.
The map, that is not very clear. So it's the same map. Take this clearer map.
The map while reading this.
No, take this clearer map. Balus. This is better.
Annexed by the judge.
Yes. So
All
this is the same thing as 15. So this is the first point. My learned friend has got, as he rightly said, on the left side, 62,397 square meters my lord has got on the left side.
Yes, Milana.
He got it in 2009.
Right.
And Malaj, the total area actually he has got is the work in progress blue and the construction not started put together is 62. I hope I'm clear, Malaj.
Yes.
The one above that is not given to him, nothing to do with him.
Right.
Now for 15 years, he has made 900 flats. And the show cause points out that even in those 900 flats, seepage, nothing. On this page, this is the plan. He is required to make 3,386 flats. That figure my lord will see.
Where construction not started.
Forget started, but the one he has made is 900.
Yes.
Not tenantable, not usable, leaking. Now, point number 1. Point number 2. So he is in default after 15 years at less than 1/4 the amount.
Where you have written 3,386.
That's correct.
Right.
Now note the second interesting point. Malas, there is an order of the same division bench on 12th of March 24, which he does not challenge. The division bench, which he does not challenge, says, if you have a problem, all of us, please issue a show cause. So I issue on his petition, under a division bench order, which he does not challenge, a show cause dated 13th March 24. That notice is found by the division bench not to be having the details. The details are there actually in the file, but we haven't put it in the show cause. So, because I have now issued to him a 30th April 24 show cause. If your lordship will see the show cause, your lordship will be shocked to what a ride this man is taking us. Now, 30th April on my show cause, his prayer is injunct Mr. Singhvi and Mr. Rodgi from issuing a show cause. That's his prayer. Now, assume, Malaj, that he replies to the show cause, which he has not. He wants to abort it. Why? Because the truth will be out. Give me a minute, Malaj. It will be shocking what he does after this. Now, yes. We are not purely interest, Malaj. We are a planning authority. We want the tenements to be made. What is our financial interest, Malaj?
I just want to add.
If Malaj, if he's not a grand, SRA is a planning authority. I have no interest in the matter other than that. I want tenements done. Now, if he was to reply,
That Rosha, why are you?
I'll tell you, if he was to reply to me, and in case I reject him, which I have not done, He has an appeal to what your lordship has created, a high-powered committee, which everybody in Bombay knows a very well-known institution.
Call it HPC.
HPC.
Yes.
If he loses there, then he has the writ. He files a writ, Wallace, when a second show cause is issued to him under the High Court order in which he is the writ petitioner. And he says in his prayer, don't issue me a show cause. It's an attempt to hide. And you will see my affidavit at page 494. I have a multiple role as a statutory authority. I have to ensure the terminations are done.
There's an appellate remedy before the HPC again.
After the HPC, your lordship has upheld the writ. So what is he doing? He's telescoping three remedies
Now,
in a one
to
leap.
hear the show cause notice at SRA.
Obliged
CEOs.
under the statute, 4 judgments, only CEO, SRA. Under the statute, see that now. See that. Well, there are 4 judgments now which say an appeal lies therefore because it is heard by CEO, no less. It lies to the HPC. Your lordship's judgments will say that are under section 13(2). Only SRA can adjudicate. 2006, 3 SCC 276. He wants to abort the entire system. Para 16. And anyway, section 13 provides, so forget all these law. Section 13 provides for 13(2). Best counsel.
Judgment says that the CEO is to.
Now, what is the point of entertaining
This document at 535. I'm going to just show it to you.
Why should you entertain this SLP?
Trying to fool. Just go to page 535 PDF. I'm going to just show you this one document.
Before
535, printed page 492.
Give me a minute more. Let me finish.
Please see this.
My affidavit.
Minutes of
494.
meeting of December
How will
20th,
you
December 20. Please see this. Your lordship has that?
494.
In the office of the CEO SRA. Your lordships have that? So September, that meeting is held where they clear it. Review meeting of the Ramabai Ambedkar SRA scheme. Review meeting held on Monday, 20th December 23 in the office of the CEO SRA along with officials. Now see, 1. To send a request letter to the government of Maharashtra to avail funds for SPPL for MMRDA to execute concerned authority SRA 1 week. To execute a joint venture agreement between MMRDA and SRA 1 month.
See 494.
Survey the slums and alignment 3 months. Request for proposal MMRDA within 1 week. So the whole thing is that the die is cast on December 2023. Time frame is set out. Meeting held in the SRA Chief Executive Officer's meeting as to what is to be done. And now he comes over here and blithely informs the court that, oh, I'm sort of an angel when it comes to fairness. And in September 23, I showed you those minutes. Everything is fine. So obviously they want to do something at some sort of, God knows what the,
I have not finished.
what the working and what's behind their mind. But this just cannot inspire even a modicum of confidence in my respect. It's all set out. No, they have a formal joint venture agreement without terminating.
After 15 years, what work have you
What
done?
work has he done?
I'll show you the photographs.
That's the crux
Please
of
see the photographs. Please see we'll just show this.
But tell us what was your obligation and what have you completed?
So over 1,000, over 1,000 slum dwellers out of 1,044 in that area of 18,000 and odd square meters are already rehoused.
How many slum dwellers are there then? Or were there when the date on your NOC date?
No, so now that will be the next phase, which I told your lordship, about 44,000 is the next phase. This is about to be completed. This is about to be completed. What your lordships will find is...
Well, they'll be in their 60s when they get there.
And in September 23, this is occupied, my lords. These are all occupied.
I think your lordship insert yourself in 136 and this.
1,000 of them.
They are not
Yes,
parties.
this is that.
Is that even the rent which was supposed to be given to us?
Mr. Kamath is not a party, my lords. He may not urge his points here. He's not a party.
Now, fortunately for me... Yeah. Give me the video, please. For me, this issue came up before the High Court in December 23.
So you see the front only, Malas, see the back. The back is all a slum. So behind the building.
In September, they couldn't
see that small patch in the map. So sure.
September, they saw only the front.
The entire thing is a slum behind. With a good. What is the name of this slum? Is the second biggest after Dharavi in Mumbai. All behind is a slum. Front he has put three showpieces buildings. In the front he has put with an old Hindi saying Hathi ke daant dikhane wale and khane wale.
No.
These are the showing teeth.
We don't have. More favored.
Necessity.
See what has
You must
happened
see
to the
behind.
High Court. Because
Hardcore
December
Park-
23, December
Hardcore Park, a lot
23 order.
better than us.
Only one thing.
See behind. All of some.
Yeah. Divan. If your defaults have taken place, we can't shield you from your defaults.
I am not claiming a complete immunity. I am not claiming
We are
that.
concerned about the fact that now that SRA and MMRD have stepped into the role of a developer in this project.
But in they pre-decided.
That any
That is
decision
answered
of
at
the show
494.
must follow a fair process.
494.
Fairness and
Just
it's evidently fair, my lord.
Just-
Evidently fair.
The only trouble is that in the face of a statute which says that the CEO has to hear, how can we
Four
supply the
judgments.
But I have
Necessity.
respectfully submitted that's
Necessity.
in a situation where the CEO is not a project proponent himself. It doesn't envisage a
Planning
situation where
authority.
you've tied up with MMRDA.
How is 13.2 worded actually?
Your lordship will see that 13.2. In fact, we've annexed it, I believe.
Because we can't just, if there's a statutory authority to decide, we can't under.
So please have a look. It's at page 68. Just have a look. And I want to just point this out.
Well, allow me to read those judgments. Allow me to read the doctrine of necessity judgments.
Please see para third.
Only
This
see
is
on
not going
website.
to inspire any confidence. It's on print page 68, PDF 111.
Get the wrong copy, show the section name. How can it be wrong in a section name? According to me, that provision annexed is not correct. This is the correct provision. It's 13.2.
And has been.
Yeah, okay.
Give a book. Show the book.
The authority design.
Where on declaration?
Now it's SRA.
Where on declarations?
All SRA.
This one? Well, this is the correct one. May I hand the copy?
This is not the
Well, apparently I am instructed, I may be wrong. Mr. Divan's client has downloaded an older version. This is the correct version.
But I think the
What does it
correct
say now?
version.
This, where,
Page
give a copy.
45.
Somebody give a copy.
Just read it. No, just read it.
Where on
Read it out.
declaration of any land as some SRA, the chief executive officer is satisfied that the land in the SRA has been or is being developed by the owners, landowners or occupants or developers in contravention of the plans duly approved or any restriction or conditions imposed under section 12, bracket 10, or in contravention of any provision of any slum rehabilitation scheme or any conditions specified in the approval or has not been developed within the time as specified under such conditions of approval, he may by order determine to develop. My affidavit says I have no monetary interest. Your lordship's 4 judgments say doctrine of necessity under 13.2. He's asking you to violate your lordship on 13.2.
Mr. Divan, we'll allow the statutory authority to, under 13.2 to.
And now the appeal lies to another body.
Anyway, the High Court is seized with the proceedings so that you
Yeah.
can always go back to the High Court.
Where is it going to be, Manoj? I'm just asking myself. I mean, who are we kidding?
But Mr. Divan, who else can we entrust? We can't supplant a statutory authority by
But in a
saying
situation
somebody else will decide.
So I would respectfully submit two broad submissions, which is the thrust of our case. In a situation such as this, where we have shown your lordships that this is all choreographed, there's a whole set plan with dates and timelines. And then you decide to issue a section 13 notice. That notice under 13, I'm not claiming immunity, but that particular manner in which it is gone is completely, it reeks of malafides, legal malafides.
On that, your petition is pending before the High Court.
Correct. But then, what's the point of this? Then let the High Court examine it threadbare.
High Court also wanted.
High
some
Court
facts.
says that, look, this is an unsustainable notice, and he withdrew the notice.
And I
So
could
that's
say,
it.
but
Then-
therefore
then-
the High Court has given them liberty to issue a fresh show cause notice. Where
True, but
A, you'll be heard. B, a reasoned order would be passed. And C, the High Court is still seized with the proceedings.
Before the High Court,
But in a
statutory body.
Milords, in a minimum, Milords, I would,
After the order is passed.
And now the, and
Milords,
now,
I would respectfully submit in a situation like this.
You are really protected for even after the order is passed. The High Court has given you more than breathing space.
But I am in a matter like this, where your lordships have seen now the who was there at the inauguration, all this big fanfare, and the purpose of this exercise.
You're right. But having said that, equally, it's impossible for the High Court to go into the question as to whether there was a default on your part, not on your.
It's
whether
under
there was no default.
226, and I would respectfully
How can the
submit
High
under
Court go into
136 as well.
Default in complying with your obligations to redevelop a slum.
So may I respond to that?
It's possible for the High Court to do
Yes,
that.
but surely, the question I ask myself is that surely
And
under
you were initially
226.
toying with the idea of appointing some officer
No,
of the
why
level of
not?
additional chief
Milords,
secretary.
I am respectfully submitting
but in the
226,
face of a
136.
statute- But in the face of a statute for a.
No, but it's not as if we are departing from the statute. The idea of the statute is to have a fair adjudication by an impartial adjudicator. In this situation, the SRA CEO can't be.
why 136 in this, fellas?
Why?
It's like this. That is the fresh over and the order.
Because I am suggesting that.
If I show cause notice would be very, it's not.
No, I don't wish
without
that.
jurisdiction.
So, because I would respectfully, both
And
under
the-
226 and
and
136, your lordships can appoint somebody, Milords, who sort of command some confidence instead of saying there's an appeal and there's 5 weeks available.
High Court is seized of the matter. High Court is seized of the matter. They have not let go because it's not that, they are going.
No, he didn't let go because they realized what was happening over here, Milords, and they got.
They have merely said, let the show cause notice be adjudicated upon. They are seized of the matter. And they have protected you for 5 weeks thereafter. It's not that, because they say that the vacation is coming, you will find it difficult to then at the last minute get a bench to hear your matter. So they have protected you right until the reopening so that you are completely protected at that stage.
We need
right?
some more time to answer the show cause. They've given us only some.
Then HPC has now become an AGRC, a statutory body. I forgot. HPC was an ad hoc body. Now it's a statutory body. He has an appeal. He has an appeal.
We have to answer.
Apart from all this, he has an extra appeal.
9th now.
9th of May.
So we need some more.
We will ask, we'll grant them time to, following the judgment of the High Court, a notice to show cause has been issued to the petitioners on 30 April 2024, following the directions of the High Court report. 30 April 2024. Full stop. While we are not inclined to interdict the hearing of the show cause notice, we extend time to the petitioners to respond till 15th May.
Yes.
15th May.
Little more. By 21st, we'll respond.
By 15, we already had so many months. So why do you want to?
Today.
Till 21st minutes. Today we are on.
Started 1 month.
2 weeks.
2 weeks.
Till 20 May 2020.
No problem.
To 20 May 2024. But stop. The hearing of the show cause notice shall proceed in terms of the directions issued by the High Court thereafter.
Obliged. Grateful.
Subject to the effort with the petition which is posed.
Item 43. 44.
Ever in 41. What it be? Lord, this will have to be.
Is also there to be.
Lord, keep it on. Lordships have it on Friday. I have a bag.
Friday, this bench may not be available.
Monday, whatever.
Then we can keep it on Friday.
Wednesday. Wednesday.
We keep it this Wednesday.
Wednesday.
So we'll complete the income tax group and then take up
Please.
the table.
Please.
44.
Mr. Rodgi, you have to give up. Mr. Rodgi, you have to give up a day's earnings to just give your voice a little rest tomorrow.
I'm going to do that tomorrow.
But I assure my friend, we will clock by 20 minutes and stop. There's nothing in this matter beyond that. Exactly 20 minutes by the clock.
Now, what about 44?
It's 44, but I'm appearing for green space. Your lordship must allow me to file an affidavit. I'm not a party here. So I'm entering appearance, must allow me to file an affidavit.
Pass the order to say that the borrower, after the issuance of the option notice, cannot any longer have any right to redeem. And in that case, your lordship that said that.
Look, Mr. Sibal is online. He was requesting for time. I'm appearing with him in the matter.
I would like to file a reply affidavit because I was not a party in these proceedings. And they are proceeding in contempt against tribunal, so I'll have to.
You are the third party to whom the transfer has been effected.
So one has allowed me to just file a reply and then take it up.
The third party goes ahead and files a suit seeking possession of the property and the borrower goes to DRT and seeks a declaration as far as the assets are concerned. So a third party, so to say that a third party can't be. Absolutely. Title deeds and possession.
Borrower.
No, I pay for the borrower. I pay for the
We are the auction purchaser.
We are auction purchaser. We have paid, we have succeeded. We have to be placed in possession. We are not being placed.
150 crore loan which I have taken.
Lord, this is the grossest.
I would like to file a reply and explain my position in the matter.
The first thing which should be done, Lord.
I paid 151 crores in this matter.
They can't be heard. They are in contempt. We must be placed in possession.
Must explain the position. Here's the question of contempt. I'm not a party.
These are all prejudicial.
You got injunction
Dr. Singhvi,
over a Supreme Court judgment.
After our judgment, how could you have created third party rights?
Not. I have created well before. And I
No.
don't have documents.
You see, our order was of the 23.
No.
Sorry, the first date of the hearing before us
September
was
23.
first date of hearing before us was 25th of August 23.
3 is your lordship's order.
And the property was sold by the respondent to Greenscape, which is Mr.
August, early August, middle
on
August
28th of August 23, after the first date of hearing before our call.
That's
The lordship
After
makes
the
a
day,
note of it in the
And,
order.
and you were on documents. And you were on caveat. Therefore, you knew that the matter was before us.
caveat, but this property sale is 26, 5 documents officially executed. Nothing in hidden, nothing hidden. They knew Mr. Goldstein never made a party.
Allow us to file a reply and then take it up.
Very short times, nobody should have a grievance that we didn't hear them.
File a reply.
I will not prejudice.
Great respect. Your lordships have noted this issue in the main judgment. If whatever it is dispendence. The first thing which has to be done is to honor the judgment of the Supreme Court. Your lordships asked me to pay extra, I have paid. You know, 140, 50 crores I have paid. I have
paid 151 crores for that.
One second. Can somebody file a suit?
Did the bank refund the entire amount deposited by the
Lord, I'm appearing for the bank.
Things for the bank.
I moved an application asking them to give their bank account number so that I can refund it to them and get the title deeds back so that I can give them.
Appellant has paid an additional amount of 23.95.
They have done that.
I have done that.
That's right.
And my lord, after a lordship judgment,
Has the bank issued a sales certificate or no?
Yes. Sales certificate we have done, madam.
And my lord, after a lordship judgment, a suit is filed. In a suit, my lord, there is an injunction making the judgment of the Supreme Court inoperative by one party. The other party goes to DRT. DRT says it's an attempt to go over the Supreme Court, rejected. You go to DRAT. DRAT says many complicated questions arise, status quo possession. Lord, is this the way the and the transferring
For the bank, I want to say something.
1 second, what we'll do
Lord,
is
they must be dispossessed. Your lordship may appoint a receiver and take possession. How can he retain possession? That's the question.
Well, before the order, point number 1, I'll demonstrate.
What is the date on which you sold it?
26th August to 28th August. Number 2, my learned friend never made them a party.
When did you file a caveat in this court?
I was here officially on caveat here, Malas.
Right. Therefore,
My learned friend never met the party knowing about.
no,
And matter
you
was
were
a
on
party,
caveat.
not party.
Dr. Singhvi, you were on caveat. You were aware of the proceedings of this court.
Yes.
And despite that fact, you have sold it to Mr. Sibal's client.
He did not make him a party. He did not make Greenpeace a
Makes
party.
no difference who are used. You are concerned then.
But the official register.
How could you have, but how could you have sold the property? How could you have sold the property knowing that we are seized of the matter?
Today's Lordship is being told willful disobedience. And let me tell you one more thing. After the order, this proceedings filed.
All right, we'll
Party
give you a short
kept
date.
it
We'll give a short date to Mr. Sibal's client and you to file your response.
Yes.
Yes. We'll
Lord, it is a gamble. We were taking the gamble. But what is the answer? Lord, ask them. Can you file it? Lord, all right, let me assume. Lord, assume in their favor. One second. Lord, assume in their favor. Can somebody file a suit over a judgment of the Supreme Court? It speaks volume.
Prima facie, it appears before this. It appears at the present stage. It appears that the respondent, bracket 1, the special petition before this court was lodged on 21 August 2023. Semicolon bracket 2. The respondent was on caveat before this court and had knowledge of the fact that an appeal had been filed. Semicolon bracket 3. The first date of the hearing of the proceedings was 25 August 2023. 4. The property was sold by the respondent on 26/28.
After entering appearance on 26th.
Started on 26th, ended on 28th. Correct. That is correct. 26th to 28th.
It was sold on 28th, no?
Finally consummated on 28th.
On 28 August 2023. Bracket, full stop. The above facts would indicate that the property had been sold during the pendency of these proceedings and conscious of the fact that this court was seized to the matter. Full stop. We already issued notice, no? Yes. We permit, on the request of Mr. Dr. A.M. Singhvi, Learned Senior Counsel for the respondent.
This is Mr. Sibal's
Mr. Sibal and I are appearing for
Mr.
respondent number 3. We were not a
Mr.
party.
Singh, Learned Senior Counsel, appearing on behalf of the transferee.
Mr. Sibal and I are
Appearing on behalf of the transferee. Yeah, are there parties here?
Yes, but on my application.
We're not parties.
1 week's time is granted to file a response to the contempt petition. Full stop. Who are the transferees actually?
Mr. Sibal's client called
Greenscape.
It's a private.
Respondent number 3. Lordship may say respondent number 3.
Greenscape.
Transferees into brackets the third respondent. The directors of the third respondent shall remain personally present before this court on the next date of listing.
Your lordships are actually
exempted
until the filing of the reply. Your lordship, there's no
Friday, ma.
No, Lord, they can't be exempted now.
Friday, ma.
They must appear.
Yes. Friday.
Incidentally, one more sentence has-
Are there any directors of any financial institution, etc. in Greenscape? Or?
We don't.
No, it's a developer.
Lord, Greenscape is an LLP. Lord.
Greenscape ही तो कह रहा.
He says it's an LLP. So,
Not director.
Well, your lordship may say Greenscape because otherwise bank is respondent number 3 in one case.
Of Greens, unka pura naam.
Greenscape IT Park LLP.
Greenscape IT Park
Greenscape
LLP.
IT Park LLP.
All right. We'll ask all the partners to remain personally present before this court on the next date of listing. We'll send them packing off to.
Your lordship will hear us before that. No?
Completely gross contempt.
Mr.
Singh, listen to us. What we don't like.
Friday week. Would your lordship say
For the first time in the written submissions filed by Mr. Rohde, this fact came to our knowledge.
Yes.
When we were hearing the matter, nobody pointed out this fact that the
It was an
no, sorry,
parties, lordship.
sorry.
We were not parties before, lordship.
Therefore, you claim
they knew about.
Therefore, you claim to be a bona fide purchaser of the property for value without notice. That will look into it. But Mr. Rohde is right. You should have respected. And second question. Second question. Why is Dr. Singhvi here? He has transferred the property. Why is he arguing the matter?
Your lordships have given notice as.
But he has already transferred. That's right. He should have said that.
He's not.
I have transferred, I have no interest.
The directors of the first respondent, you are for Bafna, no?
Bafna.
Of Bafna Motors into brackets
One
Mumbai Private
correction.
Limited shall also remain present
One
before the
question
court of
corrected,
annexed
only
labor.
because the Lordship is saying so. My written submissions also disclose that. I will show it to my Lordship.
Nobody pointed out in
So
the
may not
course
have been
of
pointed out,
the-
I was not there, but this written submission of mine discloses the same fact. What your Lordship, this is Padiwala's impression, my written submission does disclose the fact.
A very serious violation of our order.
Well, it's either this Friday or Monday.
This
Millards.
Friday?
Friday week. This
That will
bench
be
will not
last
be
working day, Millards.
Take it up.
Lord, should make it Thursday, my lord, instead of last Friday. A day earlier, it's always safer.
I may not be available for about 4
Then-
days.
then-
Then the bench was of all of
No,
us.
that's
Others, my
right.
learned brothers are sitting.
Then we will stick with whatever your lordship says.
Friday week, that is the 17th.
Yes.
Oblige, deeply oblige.
This is that bail matter, which.
Which one is this?
27 passed over. Filed our.
The anticipatory bail.
Whether it's maintainable or not if you are in custody.
Wednesday को सुनना है क्या इसको? We'll take it up on Wednesday. It's a very important point, but a short issue. Whether anticipatory bail can be granted when the accused is under arrest in another case. Maintainability. Why don't you, who's appearing on the other side? We'll close it. Yeah, you file your written submission.
Your lordship will have on Wednesday, your lordship.
Mr. Luthra is for the petitioner, I am for the respondent.
We'll hear it first on board tomorrow morning for 10 minutes. I think it's a very short question.
I'll be here.
We are prima facie inclined to take the view that you can't stultify section 438 like this. If a person is under arrest for a given offence, he can't get anticipatory bail in that case. But surely he's entitled to anticipatory bail in other offences, subject to hearing Mr. Luthra.
Your lordship
Keep
may
it
have
tomorrow morning.
Your lordship may have it on Wednesday.
We'll take it up first item before our part-heard income tax begins.
I'll be here. So I'll be here.
Now,
Your lordship,
please, now,
your lordship, can it be?
sorry,
Your lordship,
one second.
I oppose the prayer for any.
Sorry, aye. Give it now, please.
We'll take up this anticipatory bail issue, which is a 10-minute issue. We'll then reserve it for orders. We'll then take up the West Bengal matter tomorrow. And then we will take up the part-heard.
I appear for.
your lordship, three matters are also, they are.
We had an interim order in our favor saying till 6 May.
Once again, only thing, the supplementary will be notified in the night today. But since everybody is present here, we will take up the anticipatory bail first, then the West Bengal second, and then we will start with the part-heard, the income tax.
If my lords may.
Your
my lords
lordship,
continue.
No supplementary. This matter will come now.
My lords may continue the, my lords may,
It has to be formally notified for tomorrow.
my lords may continue the interim order.
No question of an interim order.
My lords, the interim order may be
Your
continued,
lordship,
it said till 6
three
May,
more
the
matters
last
are
order.
there, they may be
The
tagged
last
with-
order, that 353(8) has to be, my lords, that will have to be continued.
your lordship, for group D, there are three more petitions. There are three more petitions, they also may be tagged, your lordship.
Is it been verified, numbered? Just get it done and send an email. And look, I'll tell the registrar listing. Any other matters by the evening which have been verified, they will also be listed.
So other matters also will come also.
Only one thing which we wanted to suggest, so that we can hear the matter with a little bit of peace of mind. Why don't you, at the beginning, tell us on a sheet of paper who are the counsel who are appearing in what matter and what interest?
Category.
So we will at least, and category.
Correct.
So once you give us those categories, we can then, the hearing will be orderly. Otherwise, what happens is that, it will just become a free for all.
Yes.
So on this side, please do that exercise.
to the court
On the other side, do that exercise. And then we'll call out your, the learned counsel's names as the court master will do it in the order which you are indicating to us. It just becomes easier for us to then make notes and compare ourselves.
But that's better, brother. We can avoid this, Milord.
Asta can do it, yes. No difficulty. Ms. Asta, you do that with all your people, and this side, ask somebody to give it to the court master, at least email it by late evening today by 7 o'clock.
And my lords, that the interim order.
But some order tomorrow on, not everybody just springing up, and we are in no hurry, but let there be some order when we are. Mr. Davi, we'll be first on board tomorrow in your mind.
Your Lordship, there are 3 more matters that may also come, Your Lordship. I'll give the diary numbers.
Just ask the moment I rise, I'll tell the registrar.
The same goes with that.
So today till 9 o'clock.
This party is normally people first.
31 is where, you know, I am the petitioner. Take some time. If it takes some time.
Is along with 30.
My note,
along with
my friend is only an intervener and interlocutor.
31 is a slide.
We'll take it up tomorrow. No. Early morning we'll take it up. We'll finish off the Dave's matter, then this matter, and then we'll do well-being.
So 30.
I will tell you. I have not circulated my notes.
We have seen that. We got it.
My Lord has seen the note that Mr. Raju has submitted, my Lord. 31 is a slightly serious matter. Large number of poor investors have been due. My Lord is
Mr. Raju has circulated.
That's right.
I've already seen that. We have seen Mr. Raju.
Item 40 was to be with item.
Zoeb,
yes.
You'll be here tomorrow in case Mr. Raju is
Tomorrow I'll be
somewhere
here.
else. You'll
I'll be
here.
here.
I think 30 will rise. We'll take it up now next. We'll re-notify.
Justice Milord, Shri Krishna's report.
My Lords, we have one submission to make, my Lords. My Lords, 32 will be tomorrow, my Lords. Item 33, just.
Would it be on Wednesday morning?
33 we'll keep it on just Shri Krishna's report. No?
My Lords, I have
33, right?
33 I have a request.
33, my Lord. I appeal.
33 I have a request.
33 keep on Wednesday morning.
My Lords, can I make a request, my Lords?
Can it be after the week?
Just one.
Reply in 33.
There's an application filed by the state, my Lords. We want to file a reply to that. If my Lords, this is 1 week's time, please file a reply.
Sorry, filed a reply. We have given 10 days has gone by now.
They have not given us.
Naganand is appearing online for Mr. Naganand is appearing.
Look, he's the private party. Milord.
Yes, and if there's some urgency, otherwise we can list it whenever you want.
This situation.
2021.
Urgency is about the audit. Milord, what has happened? They commit, Milord, the Justice Sri Krishna and the meeting wanted an audit to be done from 2008.
Right.
The MUD, Milord, is objecting to that audit because they were in control from 2008 to 2000.
Lords, I don't think it's correct. Lords, they filed a writ petition before that.
So what does government of Karnataka?
The government of Karnataka, they suffered an order by your lordship.
4 people have resigned.
4 people.
Not resigned.